It's at this point, when you have to submit your ET3 in response to the ET1, that it's a good idea to consider whether you might have any need to get external legal advice, because the ET3, the response document, is probably the most important document you'll prepare, because it's the first thing that the tribunal will read, not only in advance of the hearing but also during the hearing. It's the document that the tribunal will refer to as the starting point for understanding why you are resisting the claim brought by the claimant. But you have a fairly short window in which to submit it. So from the day on which you receive the tribunal claim, the ET1, you will normally have just 28 days in which to respond. And it's important that your response very carefully deals with all of the issues that the claimant has raised, and it's okay to accept or to admit some things that they've said if you think they are completely factually correct. But obviously the reality is most of the time there will be elements of their claim that you disagree with very strongly, and so you will want to make a very clear statement within your ET3 that you deny that part of the claim, or if you're not sure exactly what the claimant is saying, again it's perfectly acceptable to state within the ET3 and within the response, it's acceptable to state that you don't have enough information in order to respond properly, and you can reserve the right to ask the claimant to provide what's known as further information in relation to the claim that they have brought. It's also a good idea at this point to get organised internally and think about whether or not it's an idea to designate somebody within the organisation as the individual who will have main custody of the process going forward, so that you can give a name to the tribunal as the main point of contact, and so that they possibly even have some space within their timetable to deal with the litigation as it develops, because it can get pretty time consuming.